Hey there, let's talk about what TV thinks is the major part of a lawyer's job: court. This is not the case. Most of your time will be spent doing legal research and writing memos for the first couple years, but that's beside the point. And you'll still need to know what the Canadian court system is like. First, let's talk about the general structure. In Canada, we do things different than in the States. Let's do a bottom-up approach. So, first off, there are courts in each province. These are provincial courts that consist of broadly an inferior court, a superior court, and then a court of appeal. This might be called by different names depending on what province you're in. For example, in Ontario, it goes Court of Justice, Superior Court of Justice, and then the Court of Appeal. In BC, the Maritimes, we have the Provincial Court, the Supreme Court of BC, for example, then the BC Court of Appeal. The most central provinces like Alberta through Manitoba and the territories have a provincial court, then the Court of King's Bench now, before finally there being a Court of Appeals. While we will discuss this later, it is important to note that provincial courts are binding on the courts of that province and merely persuasive for the courts of other provinces. However, this is not the case for federal courts, which are binding nationwide. The courts are separate to the provincial court system, save one. The ones that aren't connected are the Federal Court and the Tax Court of Canada, with the Federal Court of Appeals above that. Also, the military courts reside separate from the others, with the Court Martial and the Court Martial Appeal Court of Canada. Connecting all these court systems is the Supreme Court of Canada, which is the highest court of the Canadian system. Any decision from the Supreme Court is binding on the courts below. For example, you are a lawyer in a case, you are most likely going to end up in the lowest court in the chain, or in the case of provincial courts, either the inferior or superior court, which are usually trial courts, where you present the facts and witnesses during the trial. In these courts, you are arguing the law in light of the facts and making the case why the judge or jury should go in your favor. Juries, when they are present, are the finders of fact and will decide what happened if that is in dispute. The judge's job is determining what laws are appropriate and deciding what evidence the jury will get to hear based on the rules of civil and criminal procedure. In pure judge cases, the judge will be both the finder of fact and law. So for example, if your client, Mrs. Slippenfall, lost her negligence case, your next step would be to ask leave to appeal the decision. You have to basically ask the higher court's permission for them to hear your case. While you have the right to file a leave to appeal, that does not mean you will get leave. If you are granted leave to appeal, the panel of judges will simply hear issues of law. They do not hear any witnesses or see any evidence again. Thus, they rely on the findings of fact and go over the transcript of the case and the decision and decide if there was indeed an overriding issue of the law. There will be deference to the trial judge and will appeal only if the decision that was reached was not one that made sense given the state of the law. For example, the judge found that the business owner was not liable for the conduct of his employees. However, this goes against the principles of liability, which the trial lawyers established in the record. The judgment gets overturned and the appeal is granted. In a second example, your side has a star witness that says that there was no wet floor sign. However, the judge decided that the witness is not credible because he is Mr. Slippenfall. Thus, your case fails. The appeal court will rely on the character interpretation of the judge and will not reverse the findings, as there is no issue of law. Thus, the appeal is denied. You can acquire leave to appeal an appeal court's decision to the Supreme Court of Canada. If they grant it leave, it is usually because your case is novel or there is some uncertainty in the law that renders different provinces having different precedent. This does not happen often, however. Some criminal cases are granted automatic leave to appeal if the lower courts found your client innocent, but then the Court of Appeal overturned the verdict and found them guilty. These get automatically heard by the Supreme Court, but it does not have to be by all of the judges. Okay, small side note here. You are only guilty if you break a criminal law. This is where you will get your punishments of potential loss of liberty. You are liable in all of the other cases that do not carry criminal sanctions, i.e. loss of liberty. For example, Mr. Wet Puddle is liable for the fall of Mrs. Slippenfall. He is not guilty. Liable means responsible. He is responsible for the damage that has happened to Mrs. Slippenfall, thus must make her whole again through the damages. Mr. Slapper, however, is guilty of assault when he got angry and punched the bar patron after his team lost the playoffs. He is not liable unless a civil case is brought where there is no risk of criminal sanctions. He broke the criminal code, and thus Mr. Slapper is going to the slammer. He is guilty, not liable. Okay, sidebar over. Courts have inherent jurisdiction over the subject matter, basically meaning that they can hear all types of lawsuits and claims, except for those specifically designated to other courts by statutes. For example, the tax courts are statutorily mandated to hear cases about taxation matters. Funny that, because the subject matter is very complex, and thus they have statutory jurisdiction. On the flip side, they can only hear the cases that the statute gives them power over, meaning they hear solely taxation issues. This is because it is a specialized court that has kind of expertise compared to the average court, which is a generalized, and thus is capable of handling a wide variety of types of law. Well, that's how the Canadian court system works. You will need to know the structure in terms of stare decisis or binding precedent. To keep it simple, all Supreme Court decisions are binding on all courts. Appeal courts are being for their downstreams and only are persuasive for lateral or other appeal courts. Likewise, the decision of superior courts are only binding on their inferior courts. Though some decisions may be binding on the vertical level, at the parallel level, they are purely persuasive in terms of their legal reasoning. This will be relevant when it comes to legal research. Well, this future JD is out.